Good afternoon. The Public Safety Committee will now come to order. Madam Clerk, will you please call the roll?
Alderman Oldenburg.
Present.
Alderwoman Clark Hubbard.
Here.
Alderwoman Velasquez. Alderwoman Velasquez.
Present.
Alderwoman Sanier.
Present.
Alderman Aldridge. Chair Narayan.
Here.
We have 6 present. We have quorum.
All right, thank you for that. At this point, I will entertain a motion to approve the minutes from Thursday, July 3rd, 2025.
So moved.
Second.
All right, there's been a motion and a second to approve the minutes. Madam Clerk, will you please call the roll?
Alderman Oldenburg. Alderman Oldenburg.
Can you hear me?
We can now.
Great.
We're voting on a minute. Alderman Oldenburg, we're voting on the minutes.
Yes. Aye.
Thank you. Alderwoman Clark Hubbard.
Aye.
Alderwoman Velasquez.
Aye.
Alderman Aldridge.
Aye.
Alderwoman Sanier.
Aye.
Chair Narayan.
Aye.
6 aye votes.
All right, with that, we've approved the minutes. We're going to begin by taking up Board Bill Number 33, introduced by Alderman Devoti. Alderman, please proceed.
Chair Narayan, members of the board, members of the committee, excuse me. I appreciate the opportunity this afternoon to speak about Board Bill 33. I think it might be appropriate in this instance to give a little bit of context so you know what prompted this. First, with respect to purpose, the purpose is one that is aimed at ending dispute about the duties held by the St. Louis City Sheriff's Office. The context comes from the really items, testimony, hearings before the Budget Committee earlier this year with respect to the sheriff's budget. And then in May of 2025, specifically on May 27, the sheriff sending a letter to the mayor indicating that on a date certain he would cease transportation of detainees requiring medical attention from the CJC. Following that letter, the sheriff reappeared before the Budget Committee that happened on June the 2nd, and the sheriff himself answered a number of questions, many of which had to do with the sheriff's, not just his budget and his expenditures, but also the core duties of the office. During that particular discussion, there was agreement. I think it is fair to say that there is no dispute that, with respect to at least 3 core duties of the sheriff's office, and that is the duty to secure the courts, the duty to serve legal papers, the duty to issue and maintain concealed carry permits. There is, however, of course, a disagreement or a dispute about a 4th core duty of the office, and that is the idea, again, of the office's responsibility to transport detainees requiring medical attention from the CJC. From my perspective as a member of the committee, I found that position troubling. I also found it perplexing. History or research that was done along the way showed that as early as 1971, this board passed an ordinance recognizing that hospital administrators need issue permits to deputy sheriffs assigned to guard prisoners at city hospitals. Again, the idea being that more than 50 years ago, there was a recognition that one of the duties of the sheriff's office was to transport detainees requiring medical attention. Then in 1977, merely 6 years later, there was a case that was reported arising, of course, here in St. Louis, State Ex Rel. Missouri versus Jones, where the sheriff's duty to transport and supervise prisoners was judicially recognized. And again, we're talking more than 50 years ago. With respect to our budget committees, one of our discussions during budget was the idea that 25 years ago, one of Sheriff Montgomery's predecessors, James Murphy, recognized in writing that particular responsibility. And in fact, he used that responsibility during the budget committee to obtain additional funding. Now, your question might be, so what, or why is that important? Well, we know from a recent court filing, the Quo Warranto proceeding, that since January 1, there's at least 59 instances our sheriff's office refused to transport detainees requiring medical attention. I think this is problematic, just not from a responsibility perspective, but it's also problematic from and I'm talking now as from my background as a trial lawyer who has made a living holding people responsible of this idea of failing to recognize a duty or responsibility. So it's that context that prompted me to prepare this legislation. The notion being that there would be no dispute about what the sheriff's duties and responsibilities were. I want to point out that when the sheriff was before the committee on June 2, I point blank asked him the question about whether he believed legislation would help him do his job. In other words, would legislation specifying duties assist him in the performance of the office? And his answer was a simple yes. So, we're here today. What does this particular legislation accomplish? I think it accomplishes four things as it is presented to you. The first is that it directs that the sheriff shall have all powers and duties given him by the Missouri Constitution, Missouri statute, and city law. Again, that is something that cannot be disputed, but it's stated within this particular ordinance. The second thing is it prohibits the sheriff from undertaking certain identified duties traditionally undertaken by law enforcement agencies, which our sheriff's office, being extremely unique in the state of Missouri, is not one. And that too is established by Missouri statute. Third, it clarifies the sheriff's duties to transport detainees requiring medical attention, so that in the past, or at least moving forward, we never have this dispute that has played out over the last handful of weeks, because the ordinance specifically sets it forth. And then fourth, and this would be Amendment 2 that was sent to you and was filed this morning. It requires the sheriff to provide to the comptroller a written explanation of how the expenses submitted for payment are a necessary expense of the office. That would be the case when submitting both requisitions and contracts. And again, the idea being is that under Missouri statute, there is an obligation of the city to pay those expenditures made by the sheriff. So what we're doing here is on the front end guaranteeing that those expenses, again, are a reasonable and necessary expenditure of the office. I want to point out, too, by way of background, that this particular legislation wasn't taken willy-nilly, and I'm not here before you today just simply appearing with an axe to grind. Amendment 1, which clarified and removed and with respect to certain things the sheriff does not do, that came about after an hour-and-a-half meeting with Sheriff Montgomery. A very pleasant meeting between the two of us where we sat down and we discussed this legislation. Amendment 2 is a collaboration between me, the mayor's office, and the comptroller's. Again, clarifying this issue with respect to expenditures. I think what Amendment 2 does, and I think this is extremely important, is it answers and it guarantees fiscal responsibility of this particular office, which again, I will remind you that under state law, under state statute, the city must pay for reasonable expenses incurred by the sheriff. It also guarantees that those expenditures are necessary to perform the office's acts, those things required by Missouri statute. I want to point out, because I know in conversation with members of the committee, there was some concern of whether this body, whether the board could even pass this legislation. And so along that line, I reached out to the city councilor and received a letter memorandum saying that in his opinion, this particular board bill does comply with Missouri law. We're not taking away anything required by statute. We are simply clarifying things that otherwise are identified by statute. And it is the opinion of our city councilor's office that this particular ordinance as written passes muster. And I know that was a concern of some of you, and that is another base that we stepped along the way. So at that is the end of my presentation. I appreciate your attention, and I would ask that this committee provide favorable consideration for this particular legislation.
Thank you for that. And I'll just go down the committee and see if anyone has any questions. Alderman Oldenburg.
Thank you, Chairman. Thank you, Alderman Devoti, for bringing this forward. I just have a quick statement. First, I'd like to be added as a co-sponsor. If I'm not, please, Madam Clerk. Second, I think it's incredibly important that we do make this sort of codified in local law. It's discussed a lot in this town and down at the Board of Aldermen about taking care of our most vulnerable, right? Many folks give campaign pledges and try to find legislation that does just that. Here we have detainees who are already in a mental and physically vulnerable state, and we have a refusal of duty and a responsibility. So I applaud that this legislation sort of underscores that main component, along with the other sort of legal creatures of state law that we know sheriffs and carry out in their local communities. So I have nothing further. Thank you again, and I appreciate it.
All right, thank you for that, Alderman. Alderwoman Clark Hubbard.
Thank you, Mr. Chairman. I wanted to know, do you want us to go ahead and accept the amendments and start moving it as amended?
I figure we'll just go through the
Okay.
through the general bill itself, and then we'll go through the amendments, because there's several, and I believe Alderwoman Saunier just submitted an additional one in addition to what's already in front of us. I just want to
okay.
make sure we're getting general questions out of the way right now.
Great, I don't have any questions. Thank you. I'll just continue to listen.
Okay. Alderwoman Saunier. Alderwoman Saunier. All right. We'll circle back on her if she has anything come up. Alderwoman Velasquez.
Thank you, Chair Narayan. I have no general questions. I'm sure we'll have questions as we go through the amendments and/or if there's public comment, but I don't have any questions right now.
All right. Vice Chair Aldridge, any questions?
Thank you, Mr. Chair, members of the committee. Thank you, Alderman Devoti, for presenting today Board Bill 33 in front of the Public Safety Committee. I do want to go on record and also echo the spirit and the timeline of the bill. So being the chair of the Budget and Public Employees Committee, which you also sit on that committee. For the record, we went through our typical process where we called in every single member of different departments, from the comptroller's office all the way down to streets and various departments, to figure out and hear from their budget. Then there was a request from the Budget and Public Employees Committee to then have an additional meeting only with the sheriff of the city of St. Louis, where at that time you and the sheriff had some conversations about various of things, also other members about expenditures of money and how the department was a little into the red. And I think one key focus was a letter that the sheriff had sent out, said that he would stop doing the transport of our residents in the CJC, which really sparked that conversation. The sheriff then went on record and at that committee said that that letter, after I had many personal phone calls with him, that letter was non-void, that they was going to continue to do it. And maybe a week or two after that hearing, you filed this legislation. So I do want to go on record and say, even though you've been here a short time, you've been an honest person. Even though there's a lawsuit going on with our Attorney General and the sheriff, which I believe the Attorney General need to keep his kind of business out of what's going on in the city of St. Louis, your legislation was not filed after that lawsuit, so it was not trying to get into any politics of things. So I want that to be clear, that I've been taking you as an honest person. You've been transparent, and I know the spirit was not to get into an additional match between our sheriff and the AG. But on top of that, I will say one of my concerns, in which I know I've kind of talked to you about this a little bit, and potentially may have an amendment, hesitant maybe to offer, because I know I didn't talk with you ahead of time on it. But my concern is the fact that the sheriff office is a county office, just like the recorder of deeds office, just like the license collector office is, and I think that's the recorder of deeds, is unique by being a city and county office. And with being a city within a county, a lot of the things within those county offices are legislated by state statute. As I look at my former state representative colleague, who's now the comptroller, to be able to change things for those offices usually have to be done through a state bill. Like when the recorder of deeds want to change marriage licensees to put them online, that was something the board couldn't do, but we had to go through the state. I think some of the things in the bill, I get the intent and may be okay with, but where I wrestle with is adding requirements to a county office, which I still question if we have the authority to do. Now, I am somebody who also want the transport of our residents at the CJC to continue and not to be an issue. And if they need medical help, that they get the help that they need, because they are still under the city's watch, if it's a CJC or the sheriff's office. However, I'm concerned with Section 1 of the bill. Section 1, the last line of the bill that says the roles and responsibility of the sheriff is to transport and protection of detainees into custody of the Department of Corrections and to receive hospital medical treatment, psychological treatment. That is us adding a responsibility outside of the 3 responsibilities that are in the state statute. Can you, and I know that's also something that is being literally litigated right now between the Attorney General and the sheriff, of is this a responsibility? Now, the previous 2 sheriffs, at least I know, were doing it. But I'm nervous that we may be, as much as we all want this to happen, that we are going to pass something into law that doesn't give us the authority to do so in a county office. Can you respond to that? Absolutely. I think your mic went off. There you go. Oh, it's blinking. I got you.
Alderman Aldridge, I think that's a fair question. And when I started this process, that's exactly where I started out. I am very well aware of the relationship between the state and the county or the city of St. Louis and what can be done on the local level in conjunction with or in connection with what happens at the state level. I will point out to you that beyond the custom, beyond the fact that this is a particular duty and responsibility undertaken by this office since at least the early 1970s, that again, we don't have to go far. We can refer directly to state statute. And what I would refer, and I believe, and I don't know, and I haven't spoken with the AG about this, but my guess when the AG has taken his position, he is basing his position on section 47.450 that says all general laws relating to all sheriffs shall apply to the city of St. Louis sheriff unless otherwise specified. So that's the general starting point. So then your question might be, well, is this particular language used? And in there, I think what we do is we look at section 221.040 that talk in terms of all sheriffs shall receive from other officers all persons apprehended by the officers or committed to jail by any competent authority. And it's that particular statute that talks about the responsibility or that lays the foundation for the responsibility of a sheriff, frankly, any sheriff in the state of Missouri, to transport detainees. And again, this is something that is done that we are talking about today in the city of St. Louis, but this transport of detainees is something that is done in every other county in the state. And the basis is section 221.040, which is exactly why what this particular responsibility has been undertaken by this office for 60 years. Now, again, I haven't talked with Attorney General Bailey. I haven't looked at his briefs. I have seen no memorandum. But that was my analysis on how this particular duty is established. That is also why I believe that when we reached out to the city councilor and the question was asked, can we do this? Essentially, are we adding a responsibility that isn't otherwise directed? The city councilor said, I'm not concerned about it. I think that this is not a new duty, but what you're doing is you're specifying, you're clarifying the responsibility. And that's what we're aiming to do here. In other words, we're not adding something new onto his plate. We're simply clarifying it with very specific language that meets the needs of our jurisdiction so that from here on out, we're not arguing about this.
Gotcha. Since this is being litigated right now between the AG and the sheriff department, and a judge will rule on this, if the judge end up coming back and saying this is not a responsibility of the sheriff office and this shall not be a duty of his, my fear of even moving this forward, knowing that this part or that part of the language will be ruled on and potentially not in our favor, then we have something in law where we are not, we're putting something in law that shouldn't be in law. Instead of, potentially, I don't want to say wait, but in my opinion, in the short time that I've been at this Board of Aldermen, when there's been a need to amend the bill and add something, that has been an option to do. So knowing that this is literally this argument that we are, or the adding of the responsibility of what we're talking about is literally one of the counts that the AG is putting on the sheriff, and if it doesn't rule in the AG's favor, then we're in a pickle and can maybe be set up for then a lawsuit from the sheriff onto the city of having this ordinance into place, in which I know I have an amendment to just strike that part out, but I'm nervous with moving forward on the legislation, knowing that that part of the bill is being litigated in court. Now, for the record again, you filed this bill before the litigation between the AG and the sheriff. So I know this was not something that you added in. They actually are kind of second to the party of you. But with that being in, it gives me heartburn, since this is something being litigated right now in the courts, to move forward with at least that section of the bill.
So
Go ahead.
I didn't mean to cut you off.
No, go ahead.
Guys, I have a couple responses. Number one, as a trial lawyer, as someone who brings cases for a living, it is very usual that I will bring a case in multiple counts, which is exactly what the Attorney General did in this case. It is also very usual in a case that I bring that I press after discovery, which is what the parties are now engaged in. They're not going to try their case until November. I will press my best 1 or 2 counts. That may very well happen here. In other words, when the Attorney General tries his case against the sheriff in November, this might not be part of it. So we are standing aside on the what if, the maybe, and at the end of the day, for whatever reason, maybe because the Attorney General thinks he has a wonderful count that's a no-lose, and that's the one he presses, and he lets everything else go. We've now moved on from this legislation simply because, or simply for a what if, and that bothers me. That bothers me as a trial lawyer, and you just brought up the potential of litigation by the sheriff against the city. As a trial lawyer, let me turn the table on you. As a guy that represents families and injured people for a living, what is our response going to be, and how are we going to feel as a board if we set this aside and we don't move this along? And the 60th person that the sheriff refuses to transmit to the hospital for medical, psychological treatment, whatever, is then injured. And the next court says this is a responsibility of the sheriff. Again, we're talking about transport. Then we're all going to be wringing our hands saying we shoulda, coulda, shoulda done it. To me, the potential failure of taking care of a vulnerable segment of our society, folks that don't have choice, they are reliant upon a timely transfer, says we press forward. And if at the end of the day the sheriff decides to bring a suit, so be it. And I think this also then bears a practical consideration. We know because Attorney General Bailey brought this case, that at this point in time, Sheriff Montgomery has no choice but to say, this isn't a duty or a responsibility of my job. Because if Sheriff Montgomery said otherwise, he's just laid a prima facie case to walk out of this office. At that point, the circuit court would have no choice but to grant the Attorney General's request for quo warranto. So I hear what you're saying, but I think we also have to recognize that as a practical part of his defense, the sheriff must now take the position, this isn't one of my responsibilities. Because if he takes anything else, he's out of a job.
Would this legislation,
that's my concern.
Would this legislation need a fiscal note? Because one of the things that the sheriff said during budget was that if we have transportation, that he would need more deputies. He never gave us a number, but I'm curious, even if we pass this, and I know you said, hypothetical, we don't want to wait. And as somebody who has been one of a huge advocate that have worked with the chair to make sure we go to the CJC and stood in the gap and getting the pass of the baton from the alderwoman who passed legislation around making sure that there's a board to look into the jails. I want this to be a reality. I also know if we pass this out of committee today, say we suspend the rules on the floor and perfect it, we are going on summer break and there will be at least 3 months that this will sit. So it's not like this will go into effect immediately, and we should not also wait. And I don't want to wait, but I also want to not put us in a bind, and also understanding if we pass this, that we also know that the sheriff said that there may need to be more deputies hired on to be able to do this, which even Judge Mason said may be pulling from the courtroom. And the courtroom is a core duty of protecting the courts, which is a duty that the sheriff is supposed to do, is to protect every person in the courts. Under the previous sheriff, we've seen infighting with that sheriff not doing that. It seems like this sheriff is now protecting the courts and saying he cannot protect and not have the staff to do that. Now, I will say he didn't give us the amount of numbers that we need, but even as we move forward with this, it would be important that I think conversations amongst yourself, myself, and the budget committee continue to happen with the sheriff to see how do we make sure that now legislation is on the books, that we're not creating a manpower gap, if that's what he's saying, that he will need those deputies. And at this moment, because I also know we have public testimony, I think we've had our own courtroom here back and forth, but I still believe that I would not feel comfortable moving forward if that section is in the bill.
You bring up an interesting point, and the point is, and I will take you back to the Budget Committee in my inartful attempt to get the sheriff to tell us how many deputies do you schedule for this particular responsibility, and he couldn't answer the question. So, and I believe you as chair even said, I think what the alderman from the 5th is trying to ask is, and you threw it up there as a softball, and the answer was, I don't know. Which begs a really important question. If the sheriff can't answer that question, how do we create a fiscal note? If the sheriff can't tell us on a daily or a weekly basis how many deputies he is dedicating to this particular task, how is that fiscal note taken? One of the things that I have told the sheriff, and I believe you and I have talked about this, is that if he does his homework, if he puts together the evidence, if he's able to come back before the Budget Committee and say, this is how many deputies I've been dedicating, this is how many folks I am using, I'll be the first guy in line saying, Sheriff Montgomery has provided us with the evidence we needed. We've got to fund another 1 or 2 or whatever it is, deputies. But even he couldn't tell us that. He couldn't do it. So how do we do it as the Budget Committee? Can't guess, right?
That's all I have at the moment.
I appreciate it.
Thank you.
Thank you, Alderman. Alderman Devoti, I think this bill is timely and necessary. I'd like to be added as a co-sponsor, please, and to
Noted.
address one of my esteemed vice chair's concerns. I do note that this Section 4 is a severability clause, and so if in the AG suit moving forward, the court finds that this is not a core duty, it would be like we had just struck through that language in this bill. So I really don't share that same concern, but particularly given the fact that the sheriff came before the Budget Committee and said that this would be helpful, and that my understanding is that you've worked both with the sheriff and the city councilor's office and the mayor's office, and you're an attorney yourself, so you understand the importance of the bailiffs in the courtroom and protecting the courtrooms. It seems like you've really done your homework here, so I'm certainly supportive of this.
Just a point of clarification.
Mm-hmm.
You said that the sheriff said this would be helpful, this legislation?
That my understanding is that he came before the Budget Committee and said that this legislation would be helpful.
It was, to clarify, it was a yes or no question which I posed.
Mm-hmm.
In other words, would it be helpful if, and the answer to the question was yes.
So particularly given that fact, and that we have that we have that severability clause, that you have subject matter expertise, that you've checked the boxes on working with the city councilor, with the mayor, with the sheriff's department. I'm certainly supportive of this. At this point, I'm going to circle back on Alderwoman Saunier, whose computer had frozen up before we get into any of the, we'll get into public testimony and then amendments. Alderwoman?
Thank you, Chairman. Hi, Alderman Devoti. I've gotten to speak to you. This bill has been a topic of a lot of conversation. And, I think one of the things that I've kind of said very publicly is I'm concerned about an attorney general getting involved in like the governance of the city. And I think that we have a responsibility to show that we are capable of making our own decisions and have our own autonomy. And I think that your bill is a great demonstration of our ability to govern ourselves. That's what I think the intention of your bill is. I think it is to govern, to provide clarity on what the expectations and duties of offices are so that our citizens can be served properly. And so I commend you for bringing this forward. I think for me, I did, I was at the court case that took case yesterday, which is very separate for this. I do appreciate the Alderman from the 14th really clarified on the record that this, wasn't influenced by the Attorney General, that this isn't like a gotcha moment. Those of us who are on budget know that you've been very interested in these conversations surrounding the sheriff's office since the beginning of budget, that you really did a due diligence of digging through and asking those questions. The sheriff clarified for me himself that you and him were able to meet and have conversations. So I do think that's important to place and put on record. I do share some concerns around the transit section as well. To me, that seems to be the only part that's not very clearly stated in the state statute. And I think there's about to be a bit of a judicial conversation on whose duty it is. I would say that, my concern, not just for the legislation, but even for operation of a bill, I do think it's important that we try, and I understand that there are difficulties, to talk to the sheriff about like what are the specifics of what he needs, because something that I think we know as alders is, you can pass legislation and you can say this is what needs to happen, but it's going to be up to the people who have to do the duty. And so even if we pass the legislation, if the sheriff continues to say, again, I've not heard him say I don't want to deport, I don't want to move detainees from the CJC to medical facilities. I've heard him say I don't have the capacity to do such. I understand he has not delivered kind of documents and specifics about what that might look like. I've had some really early conversations with the budget director about what that might look like and what's needed from him to submit in that direction to show, hey, this is where my staff are, this is where they, their posts, their assignments, their shifts, and you can see based off the sheriffs we have that we just don't have the capacity to do the detainee, transit to medical facilities, which is why I'm saying that we need a creation of a jail unit. And so, I would just flag for myself, especially for those of us that are also on budget, that I think this needs to be a conversation that we have, because I think we can pass this legislation, but we still can't like physically force an office to do something. And he has said his issue is capacity, and this bill does not address the issue of capacity. I know that that's difficult because there's a number of conversations happening with the sheriff's office in terms of their budget and, where they are and what they're doing. And obviously that complicates the whole thing. But I think that conversation needs to happen on my end. I've certainly had conversations, again, with Director Paul Payne and with the sheriff's office about like, how can we get the documentation that's needed and the evidence that's needed to support that there's a lack of capacity to do these duties. So those are just kind of my concerns. I have an amendment to address my other concern, but I do, I think this bill is great. I think it is well intentioned. I think we are at a point where it is necessary for us as a board, if we're doing our due diligence, to have these conversations and pass this kind of legislation. But I do, I think it's very possible, especially given the overlap with the conversation happening in the court, that the sheriff could, once this, if it's passed and it's signed, would be signing, would be probably suing the city and saying that this is not something that's given, versus is there an opportunity here for us to talk to the sheriff and say, you know, what does it look like for you to agree to take on this responsibility officially? And I think what he's saying is he needs help so that he can have the capacity to do such.
Yes, ma'am.
Thank you for that, Alderwoman. And I guess one more question for you, Alderman, on this. You know, this bill really kind of lays out a roadmap of the duties. There's no penalty clause in this, is there?
There is not.
So really, there's no real action to take, because there's not going to be any damage to the sheriff if he were to not comply with this outside of, you know, the kind of traditional quo warranto issue that we have ongoing right now. So you know, I'm a lawyer, you're a lawyer. I don't see any standing in here to bring suit because he doesn't like what's in here, particularly if there's if the AG, if that case finds that there's not an obligation to do this. Would that be your understanding as well?
I agree. I agree, and I think what we've got to separate is the positions taken by advocates in the litigation to make a particular point. As a litigator, I understand that, but I think your point is well taken, that there would be no standing. Now, would that stop the sheriff from bringing a suit? No. I mean, anybody in the United States of America can bring a suit, but that would be met, I believe, by the city councilor's office with a motion to dismiss, which would be summarily granted. So could he do it? Absolutely. But I think there would be a very fast remedy that would end the litigation.
Thank you for that. Go ahead, Vice Chair.
Thank you. I think also the fact that, you know, we're talking about if he bring a suit of being, you know, if it get dismissed or not. We also are talking about those will be taxpayer dollars, that we can avoid that situation, in my opinion, from happening at this moment. And to say if there's no penalties, it's almost to say, well, really, what is the strength of this bill? I think the chair was trying to throw one at you in support, but at the same time, the opposite thing could be said, well, you're just putting words on paper and there's not going to be any accountability. But as we are talking about this, and we talk about the potential of putting ourselves in litigation, dismissed or not, that still requires additional funds that come from taxpayers. And I think those should be serious conversations. I mean, and we've seen short-term rentals and other things, legislation that we have passed that you cannot stop anybody from suing. And I think in those cases, we thought wholeheartedly that we were doing the right thing. I think with knowing that there is a concern that this does not, it's literally not in the state statute that this is one of the duties, then you can go to another statute that says, well, we can detail more out of what a duty is. I think just puts the city in a very gray area, and it's, you know, there's much more to this bill, but we are getting hung up on this part because I do think it is very gray.
We're getting hung up on this part because if the sheriff doesn't transport a detainee that requires emergent medical treatment, and that detainee passes away or is seriously injured while in the custody of the Division of Corrections, there's going to be a suit against the city of St. Louis. And that's why we're having this conversation. And that's why I brought this litigation.
Gotcha. And let me say, again, the residents in the CJC is something that I wholeheartedly also think we need to report on. And I want to make sure that we are doing it correctly and not politically, and that is just my stance. Thank you.
I understand that, and I appreciate that.
All right. Well, at this time, Madam Clerk, is there anyone signed up for public testimony on this?
No, we have none.
There's one.
I thought he
Please come
signed on
forward.
Board Bill 33. The Board Bill 33 sheet.
I'm sorry, I can't make out the name.
Todd.
Brother Todd L.
Brother Todd, yeah. Yep.
All right.
Sorry about the penmanship.
Could you raise your right hand? Do you swear or affirm that the testimony that you're about to give is true to the best of your ability?
I affirm.
All right, you have 3 minutes. Please proceed.
Thank you, Chairman, for giving me this opportunity to speak on this bill. I'm in opposition of this bill. I think it's in direct contradiction to the sheriff's responsibility as a county office. The alderman that's presenting the bill, he spoke of himself as being an attorney, but yet he have not offered not one piece of prima facie evidence to show the public or this board why he should be moving in that direction. The sheriff had went on record with this committee saying that even though he sent a letter, he still was transporting prisoners. He had went on record with Mr. Elliott Davis that he never stopped transporting prisoners. The aldermen have not presented to this board or the public one resident who was refused by the sheriff to be transported. Not one have been refused. This bill, it appears to be setting up the sheriff department for failure because the alderman, even though he's mentioning about responsibility, but not showing no financial assistance to this responsibility. He mentioned about Sheriff Jim Murphy, who the Sheriff Montgomery brought with this board, to this board. A sheriff that worked right there with Sheriff Murphy. And he testified that Sheriff Murphy negotiated with the city to be able to set up a unit, a separate unit to be financed by the city to overlook that particular transportation system. Sheriff Montgomery was not given the same opportunity. There's no mention of financial help in this bill by adding additional responsibilities. That's setting up for failure. The alderman went forward, mentioned about he's concerned about public safety, but I would advise him that he should be looking at bills that he can put some regulations on bad cops, because he mentioned about in his bill, he says that the city of St. Louis, which has led to disagreement, which all political people have disagreements, disharmony, disputes, and conflict between the sheriff and the courts and Department of Correction, the executive branch, and distrust, suspicion, and skepticism of the office by the public. What public is he talking about? He mentioned no data as to who has this kind of skepticism about the sheriff's office. None. But there's a lot of skepticism about the St. Louis Police Department shooting innocent people. But there's been no regulations or no attempt to bring forth policies that could prevent that. This bill is setting the sheriff department up for failure. There's not enough information to move forward on this bill. There's not enough facts to move forward on this bill. The only thing I see is things that have been aired out in the media that's driving this bill, which makes it politically. And that's the reason why the judge yesterday told there would be no cameras in the building, so they could not have snap bites and sound bites to create this kind of atmosphere. Thank you.
Thank you, sir. That'll be all. Okay. Well, at this point, Alderman Devoti, I understand that you have some amendments to this bill as we move forward. Vice Chair Aldridge, could you take over for a minute?
All right, Alderman Devoti, you are again recognized on Board Bill 33.
Yes, Vice Chair. Amendment 1 is a very straightforward amendment. Amendment 1 strictly strikes from page 2, line 18, the phrase collect and. Section 2, you might recall, is that particular part of the legislation that says the duties the sheriff shall not undertake. That came about after my conference with Sheriff Montgomery, where he made clear that the office does secure evidence. So that would be one, the striking of "and secure."
All right. I believe the Alderman would like to adopt Amendment Number 1 to Board Bill 33. Is there a motion to adopt Amendment Number 1?
So moved.
Second.
All right. Amendment 1 was adopted by the Alderwoman from the 10th, seconded by the Alderman from the 2nd. Madam Clerk, please, or all in favor, aye?
Aye.
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 Yes.
Madam Clerk, please call the roll.
Alderman Oldenburg,
Aye.
Alderwoman Clark Hubbard,
Aye.
Alderwoman Velazquez,
Aye.
Alderwoman Sanye,
Aye.
Alderman Aldridge,
Aye.
Chair Narayan. 5 aye votes.
By your vote of 5 aye votes, you have sustained the motion on Amendment Number 1 to Board Bill 33. Alderman, you may proceed on Amendment 2 to Board Bill 33 as amended.
Yes, sir. Amendment number 2 actually came about after conversation with the mayor's office and the comptroller. Amendment 2 redacts the original Section 3 that talks in terms of the sheriff approaching this particular committee when wanting to enter contracts, and rather puts forward a Section 3 that specifies the idea that the office shall provide the comptroller's office with written explanation of how the expense is necessary expense in the conduct of the duties of the sheriff's office when submitting regulations or contracts. This, of course, goes back to, again, state statute, which requires the city of St. Louis to pay the necessary expenses of this particular office. So what we're doing here in an aim at financial responsibility is making sure that the sheriff can justify through a statement to the comptroller about why that particular expense is being incurred or why the contract is being entered into.
I would open up for any questions. The chair is back, so I will pass it over for him to questions on Amendment Number 2.
All right. Alderman Oldenburg. Any questions on Amendment
No
Number
questions.
2? Alderwoman Clark Hubbard.
Thank you, Mr. Chairman. So I just had probably a couple of questions. Can you just give an example of, is this any expense or specific expenses? Just an example of, and what that process would look like between, and I know we had the comptroller. At one point, we do have representation, but even if just for clarity for people that are watching, what that looks like, and if any other offices follow that process as well.
I think a very clear example that came up during the budget meeting would be the example of the want to purchase golf carts. And we're talking about the idea being, I want to purchase 4 golf carts. And then the idea would be is that the sheriff would submit to the comptroller's office how the purchase of golf carts goes to the fulfillment of the duty of his particular office. In other words, why is it necessary to purchase golf carts to move detainees across Market Street, for instance, from the CJC to the courthouse? That would be an example.
So while I follow that example, Alderman Devoti, and I absolutely follow, and I'm in support of the legislation, just to be clear on that, but I do also follow the narrative that this is being led by some sound bites. So if we can take away that, like, just give me an example, because I want to make sure people and people watching and people know that while some people are making it for this sheriff, what we're doing is going to be here for any sheriff, right, in the future. And so we are responsible for this and making this not, we shouldn't lead or legislate off of something that's playing out in another field with what we're doing here. So,
Understood. And I think that's a fair comment. So another example. Another example would be is that, and this is another real-life example, is that the sheriff wishes to contract with the treasurer to provide certain security at parking garages for sporting events, whether it's a Blues game or a Cardinal game. That particular contract would be then run through, would be proposed to the comptroller's office. There would be a statement of necessity, and then that's how it would go. That would be an example of a service that is provided today that isn't under criticism. It's an example of a contract that was recently re-upped without any controversy. So again, that's not me just creating something out of thin air. That would be a real-life example.
I have heard that as well on my end, and again, clarifying and codifying, it will clear all of that up, I think, moving forward, and so for me, for my own assurance in this, and so that I make sure I can explain it when I'm asking the community, can the comptroller say no? There's no other way for me to put it. Can the comptroller flat out say no and deny the sheriff from his responsibility of being able to do whatever duty that he is requesting the funding for? And I guess that's kind of why I asked the process, because if it's just a simple yes or no, I don't know that I would be in agreement of that. If there's no conversation, if there's no, maybe coming to a medium, okay, if you don't need this, you don't need this, how can we do that? Even in any kind of contract, to your point, has negotiations.
Absolutely.
So, but the way I want to make sure I'm able to explain it to my constituents is, are we giving this right now to the comptroller instead of the sheriff?
Well, I think what we're doing is we're making the sheriff be able to justify that a particular contract or expenditure is related to a necessary part of his job. Once that demonstration is made, and the demonstration would need to be made to the comptroller's office, then the office would either move forward with the expenditure, authorize the contract, or not. But I think what it does is it forces the thought about, why am I doing this? And is this related to the core responsibilities of my job?
And then just again, for my understanding, the comptroller then has that purview. Does it, and others might know the answer to this, but I just don't know. Does it then go to E&A, or does it just, this conversation just stays between the comptroller and the sheriff?
The way this particular provision is written is it stays between the comptroller and it is not going to E&A.
Okay. But then even with that, I'm making sure, because I kind of caught in a glance the comptroller's representative. Just want to make sure.
Was there something to add?
Sorry, I didn't see the comptroller I'm sorry, Comptroller Behringer. I thought she had. I'm so sorry. I'm just talking like you, Comptroller Behringer. First of all, please forgive me. I only saw Ryan, and I thought that you and Mackenzie had left. So I would have never been just talking, because I would have been able to just ask you to come and answer the questions. Excuse me for that.
Would you like me to?
Okay, you can. Okay.
I'm sorry.
Thank you,
All
Ryan.
right, so, Mr.
First
Chair,
of all, this is our first time looking at Ryan in a different position. So for the record, can we please first congratulate, but then also say your name and what your position is?
Ryan Coleman, Deputy Comptroller for Finance and Development for the Comptroller. So, thank you, Mr. Chair, and Alderwoman Clark Hubbard. Just for clarity, I mean, all contracts end up at E&A. So this doesn't preclude E&A's final review.
Okay. And when you say all contracts, you're saying across the board? And
Yes, not
these
just
kind of contracts in the
sheriff's
city of St. Louis, not just
Yes.
specifically? Thank you. I think that's what I was trying to get to as well. Thank you.
Yeah, of course. Thank you.
Thank you.
Thank you. Anything further, Alderwoman?
No, I'm sorry, no.
All right. We'll move to Alderwoman Saunier. Any questions on Amendment 2?
I do, I really understand like the intention of I, I would just echo Alderwoman Shameen Clark Hubbard's point about when we start to put things in place for individuals, for entire offices, as opposed to, even though that's going to be what happens, and, special processes for certain offices, that just, you know, it just does concern me about just individual policies that are for individuals, even though they're beholden to the whole office, no matter who the inhabitant is. So I guess my question would be, for Alderman Devoti, do you foresee an end date? Is there something like, this is the case when a department goes, over budget, or, there's a reason to believe, or do you envision just moving forward? This is the process for every, sheriff's office, even though this would now be the only office that we have this in place for.
This is the process for this particular office moving forward.
And you don't necessarily have an end date in mind, or would you think like maybe if we have an election and there becomes a new sheriff, we will revisit it?
The way the legislation is written, it doesn't matter if Alfred Montgomery is the sheriff, if James Murphy is the sheriff, if Vernon Betts is the sheriff, if the next guy 10 years down the line is the sheriff. The provision applies equally to any, from date of passage moving forward.
Okay, thank you.
All right, Alderwoman Velasquez.
Thank you, Mr. Chairman. My question is either for Alderman Devoti or a member of the Comptroller's Office or representative of the Comptroller's Office. I think I do share some concerns similar to what Alderwoman Clark Hubbard and Alderwoman Saunier talked about, but can you tell me if the Comptroller, if any other office within either county office or within city government is regulated like we're proposing in this bill?
The comptroller is coming forward.
Thank you. I want to walk everyone through the process when it comes to the county offices, because as Alderman Aldridge has stated, we know that they are under state statute. So originally, the county offices were set up because there was no county government. So when they made a county government, what they said is that all the county offices should be able to sustain themselves by fees. And as long as they can sustain their office by fees, then they're separate. But what has slowly evolved, as we all know, is that the county offices are now dipping into the city general revenue, which means that's city taxpayers' money. So that's kind of the question that's been coming up over and over about any county office within the city of St. Louis. The concern right now, and this is a little different than all the other county offices, is that the county offices, we do not oversee their accounts receivable, but we do their accounts payable. They will put money into their account, which is held by the treasurer's office. But if we never see a purchase order, we don't see it come in, then we don't even know that they have money in those accounts. So what has been happening in this particular office is that when they tried to pay for some things, there was no money in the treasurer's office, so it was sent back for insufficient funds. And then this particular office went ahead and paid with a cashier's check for items. We do not in any way oversee the 5 accounts the sheriff has that they are using right now to pay for items. So that also means that you, as the elected officials and the budget, don't either see this money. And so I think that would be a concern to anyone that we don't know. I know that in the past, we had the conceal and carry, which brought in a lot of money. I know that at the state level, as a state office, county, within the city, they went to Jefferson City and they increased fees that they charge people. And so those accounts that they have over there are off of fees, off of people who are going to court or they're serving summons. So there is funds through this county office that we have no oversight on. And that's not to say I want to be in charge of anything. It's just to say I could not even tell you. So from a budget standpoint, that's kind of something I think that the alderman would want to know, and the budget committee, especially the budget chair. Does that help? Does that?
Well, no, the context is helpful, Comptroller. I think what I'm hearing, and please correct me if I'm wrong, is that no other county office would be regulated like we're proposing in this amendment.
There isn't this issue that I know of, and I could be wrong, because so far I've had no other county office go on this far over on their budget and also doesn't turn in any receivables. So for the other county offices, we can see the receivables, we can see their budget, but this particular one we cannot. And that's because they have their own accounts and they can actually print their own checks.
So I guess what I'm saying is that it does seem like this is good governance to do this in general, and that, you know, we really, in an ideal world, shouldn't have to have an amendment to ask these things, because it seems like good accounting and good record keeping, more of best practices. But we don't currently have any other ordinances in place that would regulate this quite as like this in the city.
I agree. And my recommendation to the Board of Aldermen would be that we look at that all accounts receivables for all offices, like the ones we have that are under the city, but the county as well, that we see the accounts receivable so that we can forecast their budget, so we can use the same accounting process and procedures that are used for all of the departments.
So thank you, Comptroller. From my perspective, and I do want to thank Alderman Devoti because I do support this bill. I don't think I support this part of the amendment, not because it's not best practice, but because I think, to what the Comptroller just said, to me, to regulate one county office without having the same requirements of the other county offices, I'm not comfortable with that, just because it seems like if we should do it for one, we should do it for all. And again, best practice would be, to me, that we would be seeing all of those so we could have a better financial, understanding of our finances completely in the city, which I think we should. But that the, not discrepancy, but the only doing it for one office, especially in the context of what's happened, and not that I am, I wish we didn't have to have this conversation, but we're here, but also to do this for one office and not do this for every office. Seems to be something that we're targeting one office and more than another. We should do it for everybody if we're going to do something like this. I have no further questions.
Thank you. Vice Chair Aldridge.
Thank you, Madam President, members of the board. I also don't support this amendment, but also think this is a little bit of the problem with the Section 3. And, this is why committees are necessarily working out, because if we don't accept this amendment, then we're saying all contracts should then be approved by resolution of the Board of Aldermen following the resolution at the Public Safety Committee, which absolutely also don't make sense at all. I think the Section 3 is a problem. I think this amendment is a problem. And my question for the comptroller is, when we talk about contracts, there's a difference between contracts and funds in the general revenue line item that the sheriff office can move around, correct?
Correct.
So when we talk about, because I think it's important to also set up in the context, when we talk about the sheriff's office having issues with the funding, I think there was information that was sent out, $400-some thousand of money that he went over. It was not contracts. It was general revenue money due to him letting go employees through salaries and, overtime. So this amendment would not catch that money being overspent, correct? Because that's not the contract.
I don't have it in front of me, but I think it said revenues and contracts, so I apologize. Because right now, we do not see all the
So
money.
that would mean any revenue that he want to move, if he wanted to buy 2 walkie-talkies, he would have to get your approval from his general revenue fund?
Well, I don't know what funds he's using right now to purchase anything, because there's no money. Well, now there is, now that we're in a new year.
So if it's saying any fund, if he wanted to give employees raises out of the personnel fund, which is not a contract, he would then need to get that approval through, with this amendment, through the comptroller's office.
If I understand correctly, we don't have any right to approve anyone's pay increase, only the personnel department for the city of St. Louis.
Okay, so if he wanted to move, what I'm trying to get to, so if he wanted to move money from an account from computer services to office supplies, that's usually a transfer between each department and I think Paul Payne in your office, am I correct?
Right, and that does actually happen through the comptroller.
So the moving around of general revenue funds already exists.
General
That-
revenue.
General revenue, that process already exists. Since we are solely focusing on the sheriff office, the 400-some thousand that became red and negative, if I'm not mistaken, that was salaries because people were let go.
It was due to them because they were civil servants, so it had to be paid out. It was $491,000.
Correct, but that wouldn't have been a contract. That's not a contract, that's out of our general revenue funds.
Well, I think anytime you work for an employee and you have to pay them out, that was the contract you had for their employment, but you are correct.
Okay, I get that part, but just for like the fact that was not pertaining to this amendment, for like it wasn't a contract. I think what the contract that's been going on between the treasurer's office and we talk about adding new duties, maybe that this sheriff have not been doing in previous departments. One contract that was brought up with the parking division in the sheriff office has been going on for decades and, doesn't seem to be a problem. My concern also is that we are because of what recent mishaps have happened, now we're saying let's quickly legislate it instead of trying to have a long-term solution and a long-term conversation, and we're taking this heat of the moment to say, now let's legislate where only the sheriff office will have to provide this process. And I just, for quick yes and no's, does this process happens for the recorder of deeds? What this amendment is proposing to do?
Well, we get to see the purchase orders. So if we see what's ahead, that's the difference here. So if purchase orders come in, the comptroller's office see what they're purchasing for. So instead of, it's not where you go out and pay it and we reimburse you. What's happening right now with the sheriff's office is they were going out and buying things and then asking to be reversed. It was the opposite of the way we handle things in the city of St. Louis.
So was they buying that through general revenue funds, or were they going out, let's say the car, right? That wasn't a contract, right? What was that?
That is supposed to be done through the Capital Commission. Every single year, we have meetings, and any department, including the sheriff's office, that wants to purchase cars, backhoes, you name it, even the airport, they has to be approved in that committee. Once it's approved in that committee, then it's gone in as a use that can be used for the funds from your department. So when the purchase was made, there was no purchase order. It just was taken off the floor after it was what was done to it, and then a check was cut to pay for it.
Correct.
Never a purchase order, but there was no money in the funds, the general funds of the city of St. Louis, no money existed to pay for it.
Correct. And the general revenue funds that there was no money is completely, what I'm getting to is the issues probably what we've seen with mismanagement, let's say, of the sheriff office, if it's been uniform badges, cars, golf carts, were not a contract. Those were out of fund accounts in his budget. Correct?
That would have, well, it would be put through as a purchase order through the comptroller's office. It would have been scrutinized and looked at, and we would also know whether or not you had the money to pay for it.
So where did this amendment that is being offered for contracts, how does this make a difference to try to improve that not from happening if those other items were purchase orders, not contracts. Even if the Board of Aldermen want to purchase something, purchase orders, not contracts, maybe contract with the printer service or something that we got to keep going. But those are purchase orders, which is completely different from this amendment that is talking about a contract. And what I'm aware of is there's, I think, maybe one contract, unless the alder know differently, of the contract between the sheriff office and the parking division that's been going on for decades.
I don't know of any other contracts off the top of my head, but I will point out the language talks in terms of requisitions. So we're not just talking about contracts. We're talking about when submitting requisitions or contracts related to necessary disbursements. So I understand your line of questioning. You are zoning in on one part of this.
Okay, so the requisitions, do any other department already, if they want to submit a requisition to pay for something, is the process already to go through your office?
Yeah, the comptroller's office. Just bypass, what currently happened bypassed. What has recently happened bypassed, except for, of course, when you lay people off, that would have gone through the personnel department. By law, it's a contract. You have to pay these out to any employees who are civil servants, the law.
So if it's already, I guess the law, I'm confused a little bit. One, I think, yes, we're just shadowing out one department, one county office. But if we are all, if the department is already to, each department is already to do this, I guess my question is, what are we doing by adding this, Alderman?
Because this particular department isn't playing the game the way every other department in the city of St. Louis does it. So we are specifying in this particular legislation to make it crystal clear moving forward, this is what must happen.
Yeah, and I would just,
So
you answered it. I, again, think that we are, as a new alderman and a new sheriff in a new process, I think, and a new comptroller, we're taking a moment and quickly trying to legislate, and that is without, in my opinion, trying to find long-term solutions. I think there is a bigger conversation of how this can be fixed, and we'd also love to hear from like Paul Payne as well, and other folks that would have input when it comes to finances and money moving, if Paul would have been able to be here to see how that impacts him. But we're also setting up a game for one person instead of setting up a game for the whole city. Thank you.
All right, thank you there. With that, I don't have anything further. There's been a motion and a
Roll
second
call.
on Amendment 2. Madam Clerk, will you please call the roll?
I have a point of,
We didn't
I
have-
a point
I'm
of
sorry.
clarification question. I'm sorry you didn't see me, Chairman.
Please proceed.
I just for Alderman Devoti, I know the sheriff is not here today. Was he invited here today and unable to make it? Did he share any thoughts about the specifics of these things?
With respect to this particular amendment, no, he did not.
He didn't have any concerns.
And he was invited here today?
I did not invite him, no.
Okay.
I missed the question. Can I make sure I missed, I'm sorry.
She asked if the sheriff had weighed in on the amendment or had been invited here today by the sponsor.
Okay.
All right, Madam Clerk, will you please call the roll?
We actually didn't get a motion.
I'm sorry?
We did not get a motion to adopt Board Bill Amendment 2.
There wasn't a motion to adopt before we started?
No.
He just presented it.
Alderman Velazquez,
We just, I guess for another clarification on that, this is a public hearing and obviously the agenda is public, so the sheriff could attend even if he wasn't invited. Is that correct?
the sheriff would be absolutely welcome to attend if he wanted to, certainly.
That's what I was wanting. I didn't want, that's kind of what I want, the direction I want to go in as well. It's not Alderman Devote's responsibility to invite the sheriff to this committee hearing, quite frankly. So I didn't want that to be shared in the public, that anybody thinks that this was nefariously kept from the sheriff or anything like that. These are public hearings. clearly there's a lot of attention to this, so we know this. So quite frankly, I wish the sheriff was here as well. But I just want to make sure for the public to know that that's not the responsibility of Alderman Devoti to invite the sheriff to be here today.
All right, with
I
that, I
don't want
will,
to speak out of turn, but I do want to add that it is typically when we do make bills for offices, especially when they're for a specific office, we usually do invite. But Devoti has said clearly on record that they have talked and had communication, so it's not like the sheriff is like unaware of today or that the conversation is happening. It's
no,
just,
this,
you know, typically they are invited.
this certainly wouldn't blindside the sheriff. There was also significant news coverage leading up to this that I imagine that the sheriff was aware of. With that, I will make a motion to adopt amendment number 2 to Board Bill number 33.
Second.
All right, it's been moved and seconded. Madam Clerk, will you please?
So it was moved by 4 and seconded by 2.
Yes, ma'am.
Alderman Oldenburg. I'm sorry.
Aye.
Thank you. Alderwoman Clark Hubbard.
Pass.
Alderwoman Velazquez.
Present.
Alderwoman Sanye.
No,
Alderman Aldridge.
No.
Chair Narayan.
Aye.
Alderwoman Clark Hubbard.
Aye.
One present, 3 ayes, 2 noes.
With that, we have failed to sustain the motion to adopt amendment number 2 to Board Bill number 33. Alderman, please proceed if you have further amendments.
Chair Narayan, I have no further amendments.
All right, I see that there is an amendment number 3, as well as an amendment that Alderwoman Saunier has emailed to the committee. Amendment number 3 looks like it's Alderman Aldridge's amendment. Alderman, please proceed.
Thank you, Mr. Chairman, members of the committee. Amendment 3 is one of the concerns I've been bringing up today is striking out in section 1, the last sentence that talks about that the sheriff has to transport and protect detainees. And it says Department of Corrections, so I'm curious if that, it also within that, it doesn't, I'm curious about people that are in the CJC that just been arrested by police officers. So would they not be transported? This says Department of Corrections, but that's not my amendment. My amendment just strikes out all of the transporting information that is in section 1. Again, I've worked on legislation to try to make the CJC a more humane place. I'm glad under Dr. Mahdi, who no longer is here, and a special contract that the city has passed, that our CJC is in a much better spot and it needs to continue to improve. But this is one of the things that I just don't believe is a core duty of this department. And while I want it to happen, I want to, again, make sure that we move forward and doing it the right way. In the past, it's been agreements, if that's what needs to happen under previous departments, instead of trying to legislate something that I think is one of the things being litigated. So with that, I will open up for any questions on amendment number 3.
All right, does anyone have any questions on amendment number 3?
No.
Hearing no questions, I'll entertain a motion to adopt amendment number 3. Is there any motion to adopt amendment number 3?
I'd like
So
to make a
moved.
motion that we adopt amendment number 3.
Second.
All right, it's been moved by Alderman Aldridge and seconded by Alderwoman Saunier that we adopt amendment number 3. Madam Clerk, will you please call the roll?
Alderman Oldenburg,
No.
Alderwoman Clark Hubbard,
No.
Alderwoman Velazquez,
Present.
Alderwoman Saunier,
Aye.
Alderman Aldridge,
Aye.
Chair Narayan.
No.
1 present, 2 aye votes, 3 noes.
With that, you have failed to sustain the motion to adopt amendment number 3 to Board Bill number 33. At this point, I will recognize Alderwoman Saunier. She has an amendment that is in front of the committee. Alderwoman Saunier, please proceed.
Thank you, Chairman and members of the committee. This resolution is really a copy of what is in state statute. Essentially, it is just clarifying, as state statute says, that the sheriff nor any of his deputies have to pursue the peace officer, or what is usually referred to in some spaces as the post training. And it is also clarifying that a sheriff or a deputy sheriff receiving that training would not be considered a law enforcement officer. I think that type of clarification is important because I think there's been some misunderstandings of the duties and scopes of office and who's law enforcement and who's not. So my desire is just to make sure that if this bill is passed, that is, that's clear in the legislation. And again, these are things that are in state statute, and I even reference those state statutes within the amendment.
All right. Does anyone have any questions for Alderwoman Saunier on, I guess we'll call this amendment number 4 to Board Bill number 33? Alderwoman Velazquez?
Yep. This is either for Alderwoman Saunier or for Alderman Devoti. Have you all talked about this? Is it a friendly amendment? I know it came in pretty quick to committee time, so I haven't had a chance to do my research. And I call Alderwoman Saunier, but that would be helpful in clarifying.
I'll let Alderman Devoti respond, and I'll just be transparent. He's really been busy working on many aspects of this bill, and we talked about it thoroughly. I sent him an email before I sent it to the rest of the committee and called and had a conversation just to make sure we were on the same page of where I was coming from. So I hope he landed at a place where he's okay with this, but I want to let him, speak for himself on where he is.
Yes, we spoke about it and I hadn't seen the amendment, but I heard the proposal. I heard the proposal in a telephone call. I actually didn't see the amendment in writing until I was sitting in this room. I am not in favor of this amendment.
Any further questions, Alderwoman?
Just why? You're not in favor of it, Alderman Devoti?
I haven't had a chance to do that research that I think is necessary to comment on it. I mean, again, we had a conversation at 1:45, and this hit my inbox as I was sitting in the room. I haven't had an opportunity to feel comfortable to come out and support. I haven't done my homework on it, unlike the rest of the bill. So
Mr.
for
Chair.
that reason, Alderman Oldenburg, excuse me.
It would be incredibly helpful that if the sheriff were present. Did the alderwoman from the 7th consult the sheriff on this? Is this an amendment he would like to see? Has he weighed in on this? Because I certainly wouldn't feel comfortable without sort of that triangulation and coordination of communication.
I know how diligent you are, Alderman. I did have a
I don't think you
conversation
did.
with the sheriff about this, and he doesn't prefer the whole. I'm not sure where his stance is on the entirety for the legislation, and he's not here, so I don't want to speak for him on the entirety. But I know for this specific section, he, obviously as a sheriff, he's aware that he does not have to have any of his sheriffs or any of the deputy sheriffs get this training. So to him, it is a duplication of what is in state statute, but I don't want to speak for, what he wants. I can just say that he is aware, again, as the resolution says under chapter 590, that they're not required. The peace officers, the city of St. Louis, the sheriff and sworn deputies of the office of the city of St. Louis shall not be required to obtain training and licensure by the Peace Officer Standards and Training Commission under chapter 590. So again, he's not here, and part of the reason he's not here is, I do want to be honest, to me, I think Alderman Devoti has been working hard on this, and I think who he invites to be present or those types of things, I don't want to interfere or overstep with those parts of the conversations, but I can say for this, he just reads it as that's already the case, that I don't have to have my deputies peace officer trained. As we all know, as alders, that all the deputies they're not all trained in this way.
Okay. Yeah, I certainly take your word for that, but it'd be great to have a holistic conversation. So I appreciate that. No further questions.
And you can
Thank
read
you.
the statute too. You don't even need my word.
Thank you for that. And Alderwoman, did this amendment, did you run this by the city councilor's office just by chance? Okay, because I know that the bill has gone through pretty significant work with the city councilor, and I'm not necessarily opposed to this amendment, and would be open to discussing it on the floor after it was a little bit more vetted, and after the sponsor of the bill had more of an opportunity to go through with it. I do think also, and maybe this is just me having sat on this committee for too long, it seems like we're almost going backwards with this amendment. There was a real push several years back to really encourage our sheriff deputies and city marshals to gain post-certification in kind of a post-Ferguson world, to ensure that they had the best training and were using best practices. And so even though it's not necessarily required, it was certainly being encouraged. And I wouldn't want to start walking back on that, because I think it is really useful for anyone who's in law enforcement or even adjacent to law enforcement to be aware of best practices, to have the best training that we can offer. And I do have just that concern with this amendment, that we would be kind of walking backwards some of the progress that we've made over the last decade in regard to those issues. With that, I believe the vice chair may have had something to add as well.
I was just adding real quick in response to the point you just made, Chairman, that, obviously we did not have HB 495 that took away local control a couple of years ago when you all were having this conversation. I think this was the reason why this really caught my eye is because there's some language in HB 495 that says that if someone is considered a law enforcement officer or a law enforcement entity, that they have these additional reporting requirements. And again, HB 495 just passed, that is in that bill. And so the reason why I wanted to put this clarification in the bill was to clarify that they're not considered law enforcement officers. Obviously, I can understand how folks, if you feel like you need more time to do it and to vote, I can hear that point. I would love for the sheriff to be here to do it and to vote. That's not the case, but I just know obviously we're in an ever-changing climate. And so this particular language was encouraged. The reason why I put a focus on it is because of HB 495. Just want to clarify that, as it says in state statute, that the sheriff's office are not law enforcement officers. They practice law enforcement that's relevant to their office, but SLMPD is our official law enforcement. If you guys, need more time, I'm happy to. Obviously, we're going to vote on this amendment, but send you all an email that really shows you in HB 495 kind of where that language is and where my concern is today and what I'm trying to address.
All right, anything further? All right.
I just,
oh,
Mr. Chair, just
Go
for-
ahead.
You skipped me right over.
go to Alderman Aldridge.
Go ahead, Alderwoman.
Well, I just want to say for the record to Alderwoman Senier, I'm open to putting it on the floor too. I just would need a little bit more research, and it's not something I'm super familiar with. I know that we talked a little bit about it, and I'm always in favor of clarifying things. So I would be open to that.
Alderman.
Yeah, I also agree with the Alderman of the second. Need to have a holistic conversation about this. There's a lot that has changed, and maybe need to have just more conversation about this as a whole of kind of where we are with the legislation. But I mean, I get what the Alderwoman from the 7th is trying to do. I also hear the Alderman of the 4th of how there was work done in the past to give, sheriffs the ability to get this training. I think what the Alderwoman from the 7th is saying, due to the state control law, it says now all law enforcement officers, which could be perceived as a sheriff, would then have to get post-certified. And technically right now, yes, we do encourage our sheriffs to get post-certified, but if we go off the state law, they would be required to get post-certified, which means that there's going to be more money that would be coming off, because post-certification is not cheap. I know that's one of the things previous Sheriff Vernon Betts argued when he went to the state capitol, is he wanted more funds in his department to do the post-certification because it was expensive. But I think what she's trying to do is not knock the work that the board has done in the past to encourage more training so that our sheriffs are up to the 21st century when it comes to trainings and being, aware of the different conditions. But if the state bill, and if probably need to, like some members said, more research to look at that. If the state bill, from what I've also seen from Alderwoman Tanya, is true, it requires all law enforcement, which, if I'm not mistaken, state statute is also say that sheriffs of law enforcement will have to be post-certified. And I think what she's saying is just that they're not required to be post-certified, so that they wouldn't fall under being forced to also get post-certification like our police officers. I mean, at that point, if they get the requirement, they probably would just go work for the police department. That makes a little bit more money. But I get what the Alderwoman from the 7th is trying to do, and I do get the comments from the Alderman from the 4th and some of the actions that happened at the board in the past on the post-certification.
All right.
And just in direct response, I did the direct language that is from like what is in the code says directly that the sheriff and sworn duties of the office of sheriff of the city of St. Louis may be eligible for training and licensure by the Peace Officer Standards and Training Commission under Chapter 590. So again, that's what I'm telling the committee, that this is directly from the statute. It already says that they may be eligible, that they're not required. So I'm just making this as a point of clarity in the bill, and it literally came right from the state statute.
All right. Well, at this point, is there a motion to adopt amendment number 4 to Board Bill number 33?
I make a motion that we pass amendment number 4 to Board Bill 33 as amended.
All right, there's been a motion. Is there a second?
I'm sorry, you
Second.
made a motion to pass or a motion to adopt?
A motion to adopt.
Second.
All right, it's been moved by Alderman Aldridge, seconded by Alderman Velasquez, that we adopt amendment number 4 to Board Bill number 33. Madam Clerk, will you please call the roll?
Alderman Oldenburg.
No.
Alderwoman Clark Hubbard.
No.
Alderwoman Velasquez.
Present.
Alderwoman Sanier. Alderwoman Sanier.
Aye.
Alderman Aldridge.
Aye.
Chair Narayan.
No.
1 present, 2 ayes, 3 noes.
All right, with that, we've failed to sustain amendment number 4 to Board Bill number 33. I believe that that is all of the amendments that we have in front of us. Anyone who has another one, just shout.
And I'm sorry, Mr. Narayan, that would be to Board Bill 33 as amended.
33 as amended, yes, ma'am. Do you have something?
Before we close out?
Oh, I was going to let the alderman.
Oh, I got something to say before we close out.
Okay, yeah, sure.
Thank you. I'm gonna do the, this will, before the alderman comes up, he has the ability to do, however he wants to move this forward. Again, I know we didn't adopt an amendment, and some would say we didn't adopt it, and maybe would have made this a little better. But since we didn't adopt Amendment 2 to the comptroller, which I still don't think we should be kind of legislating from one department on how to move forward. I want to first start off by saying I do appreciate Alderman Devoti for bringing this forward. I get where the energy and the spirit is coming from, even if I disagree with some of the elements of it. Section 3 would probably be even more a drag down on it, because now with Section 3, since we didn't adopt the amendment, says that any contracts that the sheriff office, try to get now have to be approved by a resolution of the Board of Aldermen, and then follow a hearing on the resolution on the Public Safety Committee, which, I don't think there's the same thing that we talked about with the comptroller, no other department doing that. There would be no other county office where their or where if they want to spend money, it has to go through a Board of Aldermen process and say we're on recess, like we're about to go on recess, and then have to wait till a Public Safety Committee is teed up to vote on that resolution. So I think the spirit of the bill, I get where it's going. I know we're going on break, so maybe there's some time to work on it before we get to the floor. Maybe if it gets out, work on it on the floor. But the way that it stands now, like I had said, I was already uncomfortable with if that transport language didn't come out, I wouldn't be in a place to be able to vote this out of committee today.
All right, well, Alderman, you are recognized to close.
Chair Narayan and members of the committee, I appreciate your consideration today and the discussion. In light of where we stand, and in the light of Amendment 2 not passing, I would ask that Board Bill 33 be held in committee for the time being.
All right, we can certainly do that. Madam Clerk, please take note at the request of the sponsor that
Noted.
Board Bill number 33 as amended will be held in committee.
Thank you all. Thank you, Alderman.
Thank you. All right, so now the last thing to take up is the Prop S, Exhibit A, the unexpended crime prevention program funds. I believe that I've spoken with most of the members of the committee after the meeting that we had last week. I'll just kind of throw it out there now. I do want to make sure that we get these funds out today. I'm going to be a no on any amendment from what the Office of Violence Prevention has put forward from their recommendations, just so I'm upfront about that. So if anyone has an amendment to Exhibit A. Oh, yeah, no, we'll get to that. Yeah. I'm just seeing if there's any amendments or if we're going to be talking about.
I mean, I have an amendment, but maybe the people from the public would change that because they've been sitting here longer than us, so I don't mind hearing from them first.
Sure. Madam Clerk, if you could call anyone who's signed up to testify.
We have Kristen Gumper from Marion Middle School.
All right. Ma'am, you have 3 minutes. Please proceed.
Good afternoon, Chairman, Vice Chairman, and members of the committee. My name is Kristen Gumper, and I serve as the Development Director for Marion Middle School. Once again, we provide transformational education to girls in poverty. Essentially, my role is to generate funds to support Marion girls and that mission, and ultimately tell their stories of profound challenge, triumph, and success. We deeply appreciate the time you spent last week talking about our potential and your advocacy to support Marion. I want to specifically address the concerns that were brought up about our submission. We received the confirmation on March 17th at 12:55 p.m. from the Office of Violence Prevention for the successful submission, and there was no other communication to any other Marion email after that, although we did include both primary and secondary contact information. While we don't know what happened electronically, we are thankful for the possible opportunity to receive funding. To clarify any questions, I have provided a printed version of the program budget, which was submitted with our grant. We have taken the liberty of clarifying our ask and what it would support. If provided some remaining funds, we would like to have half to contribute to the expanded Links program, continuing the field trips and speed networking, once again, that occur in our safe and nurturing environment when ordinarily children would be unsupervised during those danger hours, potentially at home. That speed networking also opens their eyes to what a successful future holds for them. The remainder would support our overall proven enrichment programming, specifically the camp to help build healthy relationships among young people and exposure to new experiences outside the city and contracted services. And I'm open to any questions on that. In closing, to really understand the impact of this grant to Marion and our community, you're investing in a safe and proven program that empowers young girls from the city's most underrepresented communities to flourish. Girls in communities shrouded by violence, drug abuse, and incarceration, including communities devastated by the tornado. We serve girls from 20 zip codes across the city and the region. The stories of girls who have lost their parents due to violence or incarceration moves us to double down on our work, and it's only through the support of their community that we're able to do this. Madison, who you heard from last week, is a story of hope and how we've been a catalyst for change. She and numerous family members have changed their circumstances because of Marion and the work that you're considering funding today. This is the power that you have to change lives in our city. For 25 years, Marion has remained a beacon of hope and a safe haven for students experiencing profound poverty and violence. We are a school beyond walls and a place where dreams take flight. Like Madison, her family, Lange, who you've heard of last week, and so many more. Through your support, we can help girls at risk in the city of St. Louis and help them continue to soar. Thank you.
Thank you.
Next, we have Ms. Nora Ryan, Roosevelt Community Council.
Welcome, ma'am. You
Hi
have
there.
3 minutes. Please proceed.
I just wanted to show up in person since I wasn't able to connect on Zoom last week. Again, I apologize for that. Yeah, I'm with the Roosevelt Community Council. We've been funded in every year but 2021 and 2022 with Prop S funds since 2009. So we've had many years of funding. I'm actually not here to ask you to change your list of people who are going to get funding. That's fine. But I did want you to know that there are reasons for us having a bad year, and one of them has to do with a late start due to not getting approval from OVP until November 1st. We were not allowed to start until November 1st after ENA approval and the contract process and whatnot. So they had announced that programming was going to be starting June 1st. We weren't allowed to start till November 1st. And when you're in a school year situation, that impacts your momentum. We were also impacted by the district's transportation problems and their 29 different contractors that were supposedly providing transportation to school, the lack of an activity bus after school, et cetera. I should have said ours is an after-school program, but I'm assuming that you're already familiar with the program. We also had an issue with the district, and I've submitted all of this in writing because I think this program's important, and I think it's probably more complicated and needs more supervision from this committee than what it's been getting. And then the fourth thing is that after the election, kids started getting scared about ICE coming into the school and making arrests. And there were some kids that stopped attending school. And if they're not in school, they're not going to be in after school. So we'll maybe come back next year. I'm 70 years old. I'm a retired lawyer, although my license is still active. But I don't know how many more years I can continue to provide unpaid labor and have the stress of not knowing every year whether we're going to be funded or not, and having the stress of dealing with the school district every year and all of those issues. I've submitted a written statement. I really think you need to read it and pay more attention to what's being done with this grant money. It's important for a lot of the little tiny organizations like ours. And that's all. Okay?
Thank you.
Thank you.
Next, we have Joyce Smith, Believe It Youth Organization.
Hi. We spoke on at your last meeting about
Yes,
my
Ms. Smith,
desire to
you
be
have 3
funded.
minutes. Please proceed.
Yes. We spoke the last time about my organization. I'll give you a little bit more of why I think our organization should be funded. And I also sent several letters of recommendation from the counselors at Roosevelt, who also that we co-partnered with to do several programs for the children that were at Roosevelt, that we feed hundreds of children on Wednesday and Friday. We go out into the community and we sit in our community. We go into those homes and we see what they need, and we sit and we help those young ladies or those young men. And also our program is creating such a skill for these young people. They are learning a skill that they can take with them and use with them in the future. And that's why I think it's so important to fund programs like this, because if you take a look at our data, and actually when we started, we may have had 5 students, but we go through a data collection company, and we have now about 40 children that are participating in those programs now. They are learning a skill, they're learning how to sew, they're learning how to barber, they're learning these skills, and they are doing it they're very excited about doing these skills, and these funds make that available to them. We not only do that, we take them on field trips every week. These children are getting out and they're doing things they would never be able to afford to do. And even if it taxes our pockets some, we make sure that those children still have the opportunity that other children have, and they are learning and they're sponging this up. And we just want to be able to keep continuously giving them that kind of ability, give them those skills that they can take with them. And I understand that sometimes that we, when you're new to a program, you kind of, you're learning your way. And so that's what this year was for us. We were kind of learning our way, but to see the outcome of what's going on with these children, all the children that we fed, all the children that come out in our alleys and clean our alleys for us, to make sure that we have a clean environment. This is what these children are doing, and they are very happy about doing it. And I'm very happy that we have an organization that would allow them to do it. So I just want you to take in consideration those things, look at our letters of reference, and we hope that you will see differently and fund our program.
Thank you, Ms. Smith. Madam Clerk?
That will be all.
All right. Well, do any board members have anything to put forward other than the, outside of the recommendations?
Mr. Chairman, thank you. I want to thank the speakers for coming today. I want to thank you for that additional context that not only I look forward to reading, but hearing today as well. I want to make sure that I just defend what I was speaking on last week for Marion, after hearing from the testimonies from the people that were here present then, and then this clarification that was given here today. The funding that I was thinking about possibly seeing if we could move, we did receive written clarification that by it being the surplus, we can't move the surplus. And so that being said, as much as I was advocating then for that, I know that that pathway isn't there now. But I just encourage, again, knowing the spirit of this funding that was just spoken today through the representation from Roosevelt, that these are the kind of programs that we absolutely should be funding and should be advocating for and should be in position to succeed on behalf of our youth. So I just wanted that for clarity, because my conversation won't be the same this week, because I found out that the pathway that I thought that we could go through to try to get the funding, which was not what they asked for, but something in this first request by Marion out of these Prop S funds, that pathway was clarified was not there anymore. But that does not stop my support and advocacy for this program and what I see in testimonies here, that the great work that you all do. Thank you.
Thank you, Mr. Chairman and members of the committee. So I sent, and I want to echo actually what the individual from Roosevelt said. Over the week, I'd kind of done my own homework on this program, and one of the things, after talking to the public safety office and members who actually deal with this application, she's absolutely right. When sometimes these applications go out during the timeline of, we may approve it, but they go out later than we actually thought they were actually supposed to go out. And, talking to also Clerk Kennedy, when this was originally passed, this idea was supposed to be able to support small non-for-profits who do not have the same abilities to hold huge galas. And no shade to the ones that can. We all, over time, 1 gala, 2 gala, 3, they get bigger and bigger, but there's some that just don't have that same capacity to hold big galas, that don't have the fundraising arm of regional partners that others do not. So I also sent out a email to all my colleagues, because I think it's also important that some of the individuals that will be receiving some of these funds have received them for several years, which I don't, believe is bad. But then there's some that have not received these funds that are applying for them this year, but once or twice. I don't think there's ever going to be a fair way to try to move a little bit of money around. $1 million goes a long way. But knowing that, I think there's, and I'm, whatever the committee want to do, I'm still going to attempt to, because there is some programs that are at the $100,000 mark, which I think if we shave off some, one of the ones that I'm looking at, Pianos for People, they did not ask for a lot, but they have received this grant 9 times and have been awarded these amount of fund, over 300-some thousand amount of dollars for it. Goodwill have received these funds several times, and over as well as over a nice amount of money that they have gotten in the past. Big Brothers Big Sisters have received this grant in the past. Affinia has actually only received it once, but they are a bigger organization that have the ability to fund. So if we really kind of go into the motion, Mr. Clerk, I do have several organizations that I would like to make decrease amounts on to make an increase amount on.
Do you have it in writing, or do you?
Yep, I have it in writing. So, and even the increase amount that would be going to these organizations, it will not be a lot, but I think hopefully to be able to put some type of funding to make sure that some of the work, and hopefully they may have other avenues throughout the process. So I'm looking at taking 20,000 from Goodwill, 20,000 from Big Brothers, Big Sisters, and 20,000 from Affinia, and granting 20,000 to individuals that actually came today and testified. Believe It of Youth, Roosevelt, and Mary Middle School, 20,000 each. Again, hoping that, and I totally agree with Roosevelt, one, we need to start this process sooner because the funds that we actually are allocating are from the previous fiscal year. And now we're in fiscal year FY26, where we have roughly about 800-some thousand. So hopefully when we come back from break, we start this process sooner, but also encourage members to reach out, and maybe we need to have a conversation with the Public Safety Department and Office of Violence Prevention on some of the ways that they do reporting and when they do the reporting and when they get the funds out the door. But my amendment is, again, to take 20 from Goodwill, 20 from Big Brothers Big Sisters, and 20 from Affinia, and to advocate those 20 apiece to each organization that was here today that was not recommended. But I think we're not getting a full understanding of why they were not recommended after talking to city departments and also hearing from these organizations directly.
All right, there's been a motion. Is there a second?
Second.
All right, so it's been moved by the vice chair, seconded by Alderwoman Saunier. Is there any discussion?
And
Go ahead. I'm sorry. Alderman Sanye, did you have discussion?
I think that.
Oh, okay. I just, I guess I just want to make it for public record that me not being in support of this is not a sign of not being in support of the programming. It's just this part of this process, having been down here and been through this before, there are sometimes some unintended consequences that come with doing it this way. And I trust the work that has been done to put it together to this. Again, my appeal last time was not against any of the recommendations that were made by OBP. They were for the surplus. So since I can't do that, I'm not comfortable without here going back with them with your recommendations, Alderman Aldridge. Again, not against that, not against the organizations, but having been through this before, I would not be comfortable with that until I hear from, or would have heard from OVP again, or from our colleagues who had said that they were going to possibly.
Alderwoman Velasquez, could you go on mute?
Sorry. I apologize.
I know some of our colleagues even spoke about that they were going to talk to the organizations in the last meeting. So again, nothing that, I never said I was going to do that. I only said that my appeal for that surplus. So with that being said, I just want to make it on public record why I'm not in support of this amendment. It doesn't mean that I'm not in support of the work that you all do, and I pray that you all will have other opportunities to be able to continue to do it in other avenues and be ready for this, if this is the path that we want to take next year for this funding for you all.
All right, anyone further? Alderwoman Velasquez.
Yeah, I just want to echo similar sentiments as Alderwoman Clark Hubbard. I think that, a couple of things, and Alderman Aldridge, making sure that we get to this process sooner in the calendar year. I mean, obviously not this year, for the next year. That's what we've heard over repeatedly throughout this process. But also, for me, it's important to stick to a process. And so the process that was set out was having a third-party evaluator be OVP. Because we don't have that, we thought was surplus money just because of the timing of it. I think I agree with just sticking with the recommendations that we have and then really coming to this process and evaluation earlier in the year so we can get this money to organizations before, earlier than we have been in the calendar year.
Thank you. Anyone further?
One last thing.
I'm gonna just say something. Yeah, before I let the Alderman close, I want to just expand on the reasoning behind this. I spoke last week that we had OVP come in and independently grade these applications, and they had repeated back and forth with different entities, understanding what the funding needs were of various entities to make sure that the funds that we gave were actually going to help achieve those goals, or if we were to subtract any funding, that they would still be able to achieve their goals. I think that kind of coming in at the 13th hour and cutting funds and then giving funds to entities where we're not even sure if it would help them to achieve their goal, I think it's short-sighted, particularly now that we have state control of our police department, and we're looking at fewer and fewer public safety dollars that the city is going to be able to control that aren't going to the police department. I think we need to be very, very careful with those dollars as we look to allocate them. And I think that we need to have actual metrics in place to make sure that A, we're allocating them to the appropriate places, and B, that we're seeing the best results for our dollars spent. And right now, the best way that I can think to do that is to follow the guidance of OVP and their grading. That isn't a slight on anyone who did not get funding this cycle. I know that one of the things that I had talked about with OVP, that this committee talked about with OVP when the grading started, was to make sure that we were mixing up who would be getting the funds, that there wasn't going to be any entity that survived on these funds year after year, and that we were going to make sure that there were various community entities that could get these funds. And I think that that's what OVP tried their best to do. No process is perfect. There's always going to be more issues than dollars when it comes to this type of thing. There's certainly, I think, tweaks that need to be made to this entire program. And I think that that's one of the things that we'll be discussing as we move forward. But my no vote on any amendment has nothing to do with the entities that the money may go to. It's rather to respect the OVP process and to make sure that we're not kind of picking winners and losers here at the last minute, and making sure that we're allocating our funds to get the best bang for our buck with these limited public safety funds these days. And with that, I'll turn it over to the Vice Chair.
Thank you, Chairman. I will say I think the biggest problem is it seems like we keep saying this, we're going to change the process. This committee was going to hold a hearing last week to vote out the funds, never knew who was awarded, why they wasn't awarded. We got that documentation to this committee at 10 a.m. We held a meeting at 12 and did not do our due diligence. Yes, we allow OVP to be the body to vet, but even talking to somebody who works, who I'll have to say their name, work for the city of St. Louis, saying that OVP needs a little bit more help during this process. We didn't give the opportunities for the people who is not recommended to provide documentation. We was going to vote it out that same day. There's always two sides to a story. I find it interesting that we're saying we're not going to pull funds from one organization. If I take us back to last year, this committee, and I respect everybody, but this is the same committee last year that actually we were sitting for minutes decreasing, as we say we don't want to do that and we shouldn't do that. Let's take the recommendation. We literally just did that and set a precedent. The year before, we decreased from several organizations. There was organizations that myself and other alders said we wanted to advocate for, and those meetings are public. But we did the same thing that I just attempted to do, and now we're saying, don't want to do that. We just did that the previous year. So I think we got to like pick and choose if we're going to take the recommendations or if we're not going to take the recommendations, because there's a precedent and a record set by our votes from the previous years where we actually decreased from some organizations and increased to other organizations. And we all on this committee, that still is on this committee, passed out those recommendations and set that precedent. And now we're saying, we want to take the recommendations. I think it is upon us to definitely get these recommendations a lot sooner. The money is out there right now for FY26 year. So we can meet during the summer. We can call OVP to start getting these applications out and not just take recommendations from OVP and not, in my opinion, also hear from community members on maybe why they weren't compliant to what OVP said that they were not. And I want to give the ultimate respect to the organization, OVP, that's doing the work. But we also have an obligation to do, and we literally last week was going to vote it out, thinking when we had rearage and extra money, and we didn't. And that was from OVP, thinking that we had that. There's a lot of things that need to be tweaked and more information that we need to receive from a public safety committee before we just say yes. And we didn't do that this go round, and I would close out and still move to vote to move 20,000 from Goodwill, 20,000 from Big Brothers Big Sisters, and 20,000 from Affinia, and to disperse that 60,000 to the organizations that were here today and spoke.
All right, well, it's been moved by Vice Chair Aldridge that would move the aforementioned funds. It's been seconded by Alderwoman Saunier. Madam Clerk, will you please call the roll?
Alderman Odenberg.
Pass.
Alderwoman Clark Hubbard.
No.
Alderwoman Velazquez.
No.
Alderwoman Saunier.
Aye.
Alderman Aldridge.
Aye.
Chair Narayan.
No.
Alderman Odenberg.
Aye.
All right. There's 3 ayes, 3 noes, correct?
Yes, 3 ayes, 3 noes.
All right, with that, you have failed to sustain the motion to amend Exhibit A. At this point, I'll put forward a motion that we move forward with the OVP's recommendations on the unexpended crime prevention program funds.
I'm sorry, Mr. Chair Narayan. I wanted to make sure before we continue, did you have to pass the resolution 51 before adopting or passing out this?
No, because this is just we're putting forward what Exhibit A of 51 is, and then we'll move to pass 51 out.
Okay, thank you.
So yeah, at this point, I'll move that we use OVP's recommendations as Exhibit A of Resolution Number 51.
Second.
All right, it's been moved and seconded. Any discussion?
I just want to note again that one of the things that Alderman Aldridge just said about having the due diligence and being able to have the conversations prior to having that information prior to, I know there was a discrepancy in who had the information and when we had it and when we got it. So now learning from that, moving forward again, these things are easily tracked and traced when information was emailed, when it could have been shared, when it was shared. But the timing that Alderman Aldridge just talked about, even in last year's example, is quite frankly the reason why I was challenged with voting on the amendment, is because, again, to his point, I didn't have the time. I didn't have the time to hear from the organizations that we may have been taken from. And so that I just want to note that the reasons that his reasons that he spoke of is why, again, not that I have anything against the work that the organizations were doing. I'm just not comfortable today with doing right now. And with that, I support moving forward with Resolution 51.
All right, any further discussion on using OVP's recommendations as Exhibit A?
Yeah, I got a question.
Go ahead.
Mr. Chairman, have you spoke to OVP to know if we approve this today, when the funds will go out, or are we at a time crunch that we have to do this right away? Because again, we talking about previous funds.
So the issue here is that some of this is for, a chunk of it's for summer programming. So there is some, a need for some expediency if we're going to get dollars out for summer programming.
Summer programming of the summer being right now?
Yeah, like right now, yeah.
Okay, and if we approve these already, I'm just so we're clear, the comptroller will be ready to send these funds out of the door for these organizations right away once it's approved?
That's my understanding.
Okay.
All right. Any further discussion? Madam Clerk, will you please call the roll?
So before I call the roll, Alderman Narayan, so before we allocate these funds, so we're going to do this tomorrow, just want to be clear, we will have to pass out and vote on
Yes.
Resolution 51, okay?
Yes.
Okay.
Yeah, we're right now we're clarifying what Exhibit A of Resolution 51 is, and then once Exhibit A is clear, then we'll hold a vote on Resolution 51.
Thank you. Alderman Oldenburg.
Aye.
Alderwoman Clark Hubbard.
Aye.
Alderwoman Velazquez.
Aye.
Alderwoman Tanya.
Aye.
Alderman Aldridge.
Aye.
Chair Narayan.
Aye.
6 aye votes.
All right, with that, we have amended Exhibit A to mirror OVP's recommendations as put forward to this committee. Now, at this point, I would move that we adopt Resolution 51.
Second.
Previous roll?
All right, there's been a motion, a second, and a request for previous roll. So we've adopted Resolution 51. And just to make things, to wrap it up in a bow, I move that we pass Resolution Number 51 out of committee, Resolution Number 51 as amended, out of committee with a do pass recommendation.
Second.
And I'll request previous roll. So it's been moved, seconded. There's been a request for previous roll. Is there any objection to previous roll? All right, hearing none, we have passed Resolution 51 out of public safety with a do pass recommendation.
That 51 as amended, you stated?
Yes, ma'am.
Thank you.
And do we,
What was the amendment?
I'm sorry?
An amendment to 51?
The amendment was Exhibit A.
Oh, okay. I'm making sure.
So does anyone have any announcements?
I'll just say, I do want to make for public record and for organizations that might be watching, I did, from Alderman Aldridge's question, contracts will start immediately once we make the final steps here, down here, again, for the assurance of those, not only the programming that's going on right now as we speak, but moving forward on this one, on this year's allocation, rather.
Thank you for that, Alderwoman. And all members were present, so there's no need to excuse anyone. With that, I'll entertain a motion to adjourn.
So move.
I'll second it and request previous roll.
Objection.
Okay, there's been an objection to previous roll.
Favor, aye.
All in favor signify by saying aye.
Aye.
Aye. Opposed? All right, we stand adjourned.